All rise. The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you, Ms. Bryant. Good morning. Welcome to your North Carolina Court of Appeals. My name is Chief Judge Chris Dillon. I'll be presiding today. To my right is Judge Hunter Murphy. To my left is Judge Carolyn Thompson. And we have Tom Slew as our marshal here today. We have one case on the calendar this morning. It is Sessoms versus Toyota. And if you're ready to proceed, you may start. And let me know if you want to reserve any time for rebuttal.
Thank you, Your Honor. May it please the court. Good morning. My name is Jennifer Van Zandt. I'm with Brooks Pierce in Greensboro. With me today is my colleague Graham Whittington. Together we represent Toyota Motor Sales U.S.A. Inc. and Subaru Corporation, collectively the Toyota defendants. I would like to reserve 5 minutes for rebuttal, please. This case stems out of a horrible situation. 18-year-old Matthew Sessoms was driving his 2013 Toyota Scion at highway speed when a North Carolina DOT dump truck weighing 70,000 pounds blew a stop sign. The collision was catastrophic, resulting in the death of Mr. Sessoms. The car Mr. Sessoms was driving was the product of a joint venture manufactured and tested by Subaru and sold and distributed by Toyota.
Did the truck hit the side of his car? Is that what happened?
It did, Your Honor.
Okay.
The bumper impaled the car.
Okay.
Plaintiff added the Toyota defendants to the case in 2022. Both defendants agreed to waive the usual service requirements for foreign corporations. Plaintiff's theory is that defendants should have designed a sports car that would withstand a collision at highway speed with a 70,000-pound loaded dump truck. And because the trial court disregarded the law, relied on unsupported factual assumptions, and abused its discretion, without the intervention of this court, a jury will never be called upon to decide my client's liability.
Well, let me ask that. When I looked at the answer and everything struck, has causation been determined as part of this as well? As part of the sanction and the portions of the answer that are struck? Or won't the plaintiff still have to prove that the deceased was alive and conscious and suffered pain and suffering, or wouldn't have died just by the impact itself? Isn't that still going to be an issue for trial?
The admissions included that were deemed admitted were included that the vehicle was negligently designed and that the design caused the death, I believe. And so, yes, Your Honor, they will have to prove the damages, and so they will have to prove that the plaintiff was still alive and in the pain and suffering. But in terms of causation,
So
no.
that was a sanction. Okay. That's a sanction that it was
exactly.
faultily designed and it caused the death, or was a cause.
And that it was an unfair and deceptive trade practice. Further, which leads to, as the court's aware, additional treble damages and attorney's fees. So here we have two orders. The August 10th, 2023 discovery order, and then a sanctions order entered on December 1st based on an alleged failure to comply with the discovery order.
And I would say there's a lot going on here, so you have to cover each one at a time. So when you get to this one, tell me why you think that's an improper sanction. But I mean, just go through each one.
I will, Your Honor. But first I was going to address the appealability briefly of them, because the plaintiff has raised that issue, if that's okay with Your Honor. But this court and the Supreme Court have ruled that when you have a sanctions order, the underlying discovery order sort of travels with it. And we see that in Fiasco, we see that in In-Ray Pedestrian Walkway. And in fact, even as recently as July 2nd, this court noted in Jesse Sports that there was a sanctions order that was appealed, that the discovery order would have come on, except that the defendant had failed to list that order in his notice of appeal, which of course we did. And so both orders are properly before the court. They affect a substantial right, And should the court have any issues about jurisdiction, we have pending a writ of certiorari for the court's consideration. So there are 6 important errors here, Your Honor, in both orders. 1, that the responses violated the rules of civil procedure. 2, that the objections to document requests and a deposition notice were untimely. 3, that all objections to a 30B6 deposition were waived. 4, that resumed depositions should occur in Robeson County. 5, that the defendants were obligated to create English translation of documents. And 6, that defendants unlawfully destroyed documents. So first, the plaintiffs asked the trial court to find that the defendants' responses to the interrogatories and requests for production documents did not comply with North Carolina rules of civil procedure. Plaintiff gave no other detail about which requests were problematic. There was no information about what was wrong with the requests. The responses were offered, and all plaintiff offered was an unsworn summary that had no detail with just cryptic notations. This portion of the discovery order will be reviewed under an abuse of discretion standard, and we contend that the trial court abused its discretion in making these blanket findings that the responses violated the rules of civil procedure.
So they're saying that you didn't produce everything. Do you have any idea? Have they said at all what you didn't produce? Like, you didn't produce the documents from this time. There's nothing in the record that says what wasn't produced. So I'll ask you if there was, but there's nothing. You have no idea what they're saying that you need.
That is
they need.
exactly right, Your Honor. Other than just unsupported statements of counsel, we had coming out of that discovery order.
So you're saying you produced everything you're supposed to, and they haven't articulated to you, well, you didn't produce this stuff.
Right. They say you should have produced design drawings, but they don't have any evidence that those design drawings actually existed. And I'll talk about that when I address the spoliation. So
everything they said that you produced, you're saying you did produce all that you had.
That's correct, Your Honor.
Okay.
And we have affidavits to that effect in the record.
And then there's nothing else. Okay.
And then there's nothing
And
else.
you're also saying, just to be clear, that you're producing everything you've ever had at any point.
Well, Judge
That you
Murphy,
still
to
have.
the extent, of course, it still exists. Yes. That was what was called for, except for to the extent there was a valid objection. And there's been no specific overruling of specific objections.
What's the benefit of submitting them in Japanese?
The benefit,
I
Your
mean,
Honor?
but why, if you already know, it creates delay that you got to go back and ask to translate. And what was the purpose of doing it and submitting it in Japanese instead of just upfront handling it?
Well, so the documents exist in Japanese. There's no requirement. Rule 34 only requires that you produce documents that exist. There's no affirmative obligation to create a document. And the cost of translating these documents is very onerous. It costs, this in the record, that it costs approximately $10,000 to have 10 of these translated. That's because these are Japanese companies, of course, and the work was done in Japan originally, and their technical design documents, we don't know that they're needed. We don't know what exactly plaintiff wants to do. We produce the documents we have. There's only been one court anywhere that has ordered production of Japanese documents or translation of documents. And respectfully, that was a 1975 decision from a different era in terms of our global economy.
Yeah, but it costs that much just to put it into litigation to require you to have it translated. I mean, you're talking about it costs $10,000 to have it translated, but by the time you go back and forth through civil proceedings, you spent that money anyway, just instead of doing it up front in good faith.
Well, it was $10,000 for 10 documents. There are 133 documents at issue. And we offered to split the costs with the plaintiffs. And the traditional approach in the United States, of course, the American rule is that parties bear their own costs of doing discovery. And every translation that we had, we produced. It's not, there's conjecture in the briefing that surely they have them in English or they wouldn't have produced them. Well, we have an affidavit saying that that's not the case. The second significant error made by the court was that it struck all objections to the document requests that were included with the 30B6 notice. Now this, we contend, should be reviewed de novo, because when Justice Barringer wrote in 2020 that when we construe the rules of civil procedure, we're engaging in statutory construction, and that is a matter of law.
Say that again. Who said what?
Justice Barringer in 2020 wrote in
He wasn't on the court in 2020.
oh, I'm sorry, 2022. Thank you, Your Honor.
I'm sorry.
I think my math and brain was going off a little bit on that, too.
Yeah,
What was the case?
in
Or just the
matter
site, or
of
just the site, or what's the site?
It's in matter of EDH, Your Honor.
Do you have the site?
I will procure that.
That's fine.
Thank you. So she said, when we look at rules of civil procedure, we construe them de novo. Here,
So what objections did you have? So get specific. So what?
okay, well, so we had a whole set of objections to the document requests that came with the notice. And as you know, you can include document requests with a notice of deposition. And we had 7 days, according to the rule, before the deposition to serve our objections. But the plaintiffs decided and told the court in their motion to compel that it was a 14-day deadline, which the court adopted and said, I don't care what those objections say. I'm not looking at them. I'm not counting them. They were late. And that is
So
the error.
you're saying the trial court judge, even if it was a discretionary thing, abused discretion by not even considering the objections?
That's
And
correct.
the court has no authority to make it 14 days. It has to be 7 because that's what the rule. There's no authority to do anything different.
That's correct, Your Honor.
And so you had objections. So let's say you have objections. Let's say you file objections 7 days in advance.
Mm-hmm.
Does that mean you don't have to produce them until the court rules on your objections? Is that how depositions work? I was a banker. So.
Oh, so that goes to the topics. This is going to the document requests that came with the deposition notice under 30B5.
And your objections were to the document request for what reasons? I mean,
Just the normal, usual,
so if you object, does that mean you don't have to produce them until the court rules on your objection?
That is the way, yes, Your Honor, that the document requests are handled, that until there's a motion to.
So a week before the deposition, you can serve these things, and the court's supposed to, in the interim, rule on it, I guess? Is that?
Oh, well, Your Honor, only if there's a need for a motion to compel. I mean, parties make objections all the time that don't actually come to court. They're worked out, they're boilerplate, I'm not suggesting ours were boilerplate, but they're to preserve rights. But here.
So you objected and the court would not rule on your objections. So did you ever produce those documents?
So those document requests were largely overlapping with the earlier ones. So no, we did not produce.
That's fine. That's right.
So turning to the 30B6 deposition topics, Your Honor, the plaintiffs served notice of deposition. Defendants objected to the topics. There was no motion to compel.
Is this your third thing?
It is, thank you.
Okay, I was just making sure I'm tracking.
There was no motion to compel. There's no protective order. The plaintiff contends, and the trial court agreed, that because the Toyota defendants did not seek a protective order in advance of the deposition, that all of those objections to the topics are gone. So let's talk about 30B6 deposition notices.
Real quick, just before you
Yes, sir.
I just want to ask one just clarifying question. These depositions occurred, I think they were California and Texas is where they occurred. What was the process between the litigants to arrange for these depositions to take place in those situations, in terms of scheduling, in terms of what the topics were going to be, what kind of witnesses they were looking for? It doesn't just seem like it was noticed up, come down to the county courthouse next week, and that we're going to depose whoever you bring. It sounds like there was some planning on who this was going to be and the like.
So originally, for the depositions that did occur, they were set by agreement in terms of the date and the location, because some of these witnesses are from Japan, and so they agreed to bring them to, easier places, like kind of a middle ground, right? And that we had served the objections to the topics, and the issue is whether.
How much time between scheduling and figuring out who was going to come, and then you got the request for the documents and then the objections? What's the timeline there? I guess what I'm really trying to boil down to, and I don't want to jump around it, but Rule 34, it says unless otherwise stipulated when we're talking about production of documents. So I'm trying to see, was all this agreed to in scheduling, and then we just have later objections? So the timing mechanism isn't really an issue. It might have been covered by stipulation or some type of consent by the parties in scheduling?
So, Rule 34, of course, governs the production of documents. And so I covered that in my second point, and that was the 7-day versus the 14-day. Now, the deposition topics, I believe there was plenty of time for the plaintiff to seek a protective order. For the plaintiff to seek a motion to compel, had they wanted to. But typically what we see in practice, and what's borne out by the 10 cases that we cited in our primary brief and 4 more in our reply brief, is that parties engage in writing letters or objections about the topics, and then they go and take the deposition and see what happens. And then after that, if they need to, they go to court. I'm
just making sure I understand this works. So they said, we're going to depose these witnesses and we want to cover these things.
Yes.
You let them know we're going to object to these topics.
We did, Your Honor. And we did in advance. We sent.
And so at the deposition, these witnesses did not testify to these topics because y'all objected to it.
And that's right. And so then the issue is did we waive that, or can that be addressed on a motion to compel? That's the issue before the court. So
What are they saying? You should have gone to the court and said, we don't want to talk about these at a deposition, rather than you just make an objection. And
that's right, Your Honor. In that position, if that were the rule, that would clog our trial courts. 30B6 depositions are taken every day. And the practice, as reflected in these cases that we cited, is that parties engage in a letter exchange, and then they see how the deposition plays out. If there's any issue left, then they go to the court.
do you perceive there's any argument, did your witness answer every question they asked that was not objected to?
I don't believe that they were instructed not to answer in particular, on particular issues.
But you let them know in advance what you objected to with the topics. Okay.
We did, Your Honor. And Rule 37A states that if a party fails to make a designation, then the party seeking the discovery may move to compel. So the trial court
Well, it wasn't about making a designation, about objecting to the topics. Isn't that right?
Yes, Your Honor, but the cases we cite say that that's what, when you say to me, Ms. Van Zandt, give me a witness on these 5 topics, and I say, respectfully, Judge Dillon, I object on topic 3. I'm not going to designate a witness on that. Then that invokes Rule 37A, which would require you to seek
Which
a motion to compel.
would require them, okay, and they never did that.
That's right, until,
But the trial court sanctioned you for not,
exactly. And,
okay, I got that one.
Your Honor, Judge Murphy, you asked me about the timing of the notice of the depositions were served on April 18th, 2023 on Toyota, and May 16th, 2023 on Subaru. And then objections and responses were served May 22nd and June 1st. And then the depositions were taken June 22nd and July 6th. And that can be pages 3 and 4 of the index to the record on appeal sort of sets that timeline out.
Thank you, ma'am. I appreciate that.
Thank you.
Talk to me just a little bit about this interplay with the topics and Rule 30D with the motion to terminate or limit the examination. Is 30D not related to this topics issue, which seems to put the onus on the party seeking to limit the scope of the examination to move the court to limit that. So talk to me just a little bit about that topic designation and the interplay with 30D and who has that burden.
Right. So, Your Honor, so Rule 30D says that at any time during the taking of the deposition, on motion of a party or the deponent, and upon a showing that the examination is being conducted in bad faith or in such manner as unreasonably to annoy, embarrass, or oppress the deponent of the party. And so that is what 30D is for. 30D doesn't relate to an issue over the scope of the deposition in terms of 30B6 topics. To me, 30D is, somebody asking about.
This is during the deposition, there's a
Right,
question
ridiculously personal questions,
Okay.
terrible situations. Okay. If Your Honors agree, I'll turn to the fourth
Number 4,
topic.
yeah, I want to hear all of it.
The fourth key error that we contend was made was that the court required the witnesses to be produced in Robeson County on redeposition. Rule 30 is really very clear about where deponents may be to have their deposition taken, and federal cases make it clear that a 30B6 deposition takes place at the entity's principal place of business. The K2 decision cited by the plaintiffs is not to the contrary. That case addressed the appealability of the order, not application of Rule 30. And so here, we contend the court erred by ordering the depositions to be resumed in Robeson County. The fifth point is the translation point, which, thanks to Judge Thompson's questions, we touched on. And Rule 34 just requires production of documents in the possession, custody, or control of a party, and doesn't require the creation of new documents. The cases are legion, and that translation is not required, and there is no contention here, there's no supported contention that any translations exist which weren't produced.
Is there anything in the record that shows that you offered to pay for half of it?
Yes, Your Honor, that's in
I
Patrick
can find
Cleary's
it.
affidavit.
Yeah, that's fine, okay.
Turning to the sixth issue.
And you were sanctioned for not translating them. You were sanctioned for all these.
Yes, Your Honor, we were ordered to produce the translations in Japanese and then sanctioned for not doing so.
Okay.
Even though we were underway and working hard to translate them because there was a court order. And then the next set of documents was going to cost an exorbitant amount of money. The sixth is that the trial court erred in two ways with regard to document retention issues. First, it abused its discretion by requiring defendants to log every single document ever possessed. That was an impossible task, and it set the defendants up for later sanctions. This issue, it wasn't even in plaintiff's motion to compel, but later appeared in their proposed order, which the trial court adopted wholesale.
That means there's a log, so if things have been destroyed, you were required to list everything that was destroyed.
That's right, Your Honor.
Okay.
From 10 years ago. There's no record evidence that all existing responsive documents have not been produced. Plaintiff cites to 30B6 testimony from the Subaru witness at record 1036 through 42. That witness testified that certain testing had been performed, but there was no testimony saying, and then what documents were generated, and where are those documents, and do they still exist, and if they don't, when were they destroyed? All the testimony says is that the testing happened.
Wouldn't it be if a car manufacturer is doing testing, wouldn't it be just a basic assumption and appropriate for the trial court to assume a document was made as a result of a test?
Perhaps, Your Honor, but there's no, we don't know. The test could have just been done and then moved on.
But
The trial court can't make reasonable assumptions in determining sanctions?
You know, in the face of affidavits from the witnesses that everything has been produced, I'm not sure the trial court can go that far.
The trial court gets to weigh the credibility of those affidavits, right?
Yes, of course.
And would be weighing the Subaru testimony in light of those affidavit testimony or evidence.
Yes, but respectfully, when you line those two up, it doesn't get to any conclusion that documents were destroyed or when they were destroyed. Plaintiff argues a document retention policy was violated, but there are many, many cases we cited that that's not adequate evidence of spoliation. Plaintiff points to a legal agreement from 2014 that references work product and argues that defendants were on notice in 2014 that litigation would ensue. Now, spoliation, though, requires specific knowledge of specific litigation. There's no law that would support a conclusion that in 2014, defendants could be on notice that documents should be retained based on an accident that occurred in 2021. Under this approach, as urged by the plaintiffs, every manufacturer of every product that could be involved in a fatal accident
And you're bumped up on your rebuttal time.
thank you, required to retain every document ever created. The sanctions order, Your Honor, flows from the discovery order. It's infected by all the same errors. It has to fail. It decides as a matter of law the liability of my clients. And in Wagner 269 NC App 2020, this court held it's improper to base the grant or denial of a motion for summary judgment on evidence of spoliation. But that, in essence, is what this court did. Because these 6 errors infect the whole sanctions order, and the sanctions were disproportionate to any harm, they violate this court's admonition in Moore v. Mills 2008 that imposition of sanctions that are directed to the outcome of the case should be reviewed in light of the general purpose of the rules to encourage trial on the merits. Your Honor, I'll reserve the rest of my time for rebuttal, but we respectfully request that the trial court's orders be reversed.
Morning.
May it please the court, good morning, Your Honors. Noah Abrams from the Wake County Bar, along with Melissa Abrams, my law partner, and Will Owen from the Robeson County Bar. We have the honor of representing Matt Sessoms' family. Your Honors, this is a simple case. The defendants hid the existence of information and documents critical to this product liability action related to design, testing, and other prior incidents in which the Scion vehicles were subjected to engine fires and subjected to failures of the structuring in crashes. The court's ordered that they supplement these documents, and they didn't do so, and they violated the court's order. The trial court saw through this conduct. They recognized the gravity of what happened, and they recognized the harm that they've done to our ability to represent the Sessoms family in this product liability case by refusing to produce documents and refusing to identify individuals that are critical to the issues that the court did find in our favor on, and that was solely issues related to negligent design, negligent manufacture, the existence of a feasible alternative design, the existence and breach of a warranty, and that their conduct was unfair and deceptive. Now, what my colleague argued when Judge Murphy had asked about the nature of the sanctions, my colleague argued, and I think she's just wrong, I don't think it was intentional, that product proximate cause was an issue. And that's just incorrect. Or excuse me, the proximate cause was determined. That's just incorrect. And I put it in my brief, so I want to make sure that I was accurate, and I went back and highlighted the specific paragraphs involved.
Well, let's start with number one. Okay, so the sanction, she says, was that they've admitted that it was a faulty design and it caused it to death, and there was an unfair and deceptive trade practice. What did the court sanction? So what's left for the jury to determine
What is left for the court
besides damages?
is causation, is whether these defects cause Matt Sessoms to be trapped in the vehicle and burn alive. That is what is left for the jury, as long with the issue of damages. And they talk about a 70,000-pound truck and that it wasn't a survivable crash and talk about forces. That's still an issue for the jury. The jury can hear that under the sanctions order.
So they could hear that even if it was faultily designed, it would have, if it was properly designed, it would have buckled anyway, because it was, I mean, they could still make that determination.
Right, and the credence that the jury's going to give to that when the passenger walked away with no injuries, that's not for this court to determine. But that is an argument that...
Did the judge find that it was faulty design, not based on any evidence, but as a sanction for their inability, their failure to produce documents for you to...
That's correct, Your Honor. They, he specifically, the court...
we're just going to deem it admitted.
Deemed certain paragraphs of, and it is in, basically, don't have to take my word for it, the order, the portions of the order on it are, start at record page 1894, paragraph 35. And the court stated that in its discretion, under Rule 37B2, found and concluded that the following sanctions are necessary and appropriate to remedy the violations by Toyota Motor Sales and Subaru. And then it went on to list specific facts that is, that are deemed admitted, which is a sanction that is allowed, specifically allowed by the rules, and allows the court to exercise its jurisdiction and do. And it said that they designed and developed it jointly. They had a joint obligation to ensure that the vehicle was reasonably safe and free of design and manufacturing defects. I'm not going to read all of it because I don't want to use up all my time.
Well, let me just ask, maybe a little shorthand. The defendants have attached their Appendix A, starting at 14, this basically annotation of the complaint and what was deemed established by the sanction order. Do you have any opposition with that summary, or have you just not? You don't want to say one way or another.
I've got it in that notebook right there, Your Honor. In the banker's box, I have their appendix. But I think as long as, I mean, I would hope that they'd be able to circle paragraphs right. But the paragraphs themselves are listed. I think there is a typo that I'm sure they're going to argue about. On 1896, there's C. Subparagraph 1, I think that's supposed to be 106 rather than 116, and we'd stipulate to that. And subparagraph, because that fits, and then subparagraph 107, A through G and I. And then paragraph 108 is the paragraph on causation. That the negligent and grossly negligent, willful, and wanton conduct of, in this case, Subaru, is approximately caused the injuries that we're complaining of. So that's that. I mean, the remaining paragraphs, it all talks about the breaches, that there was a warning, that the warning was breached.
Well, I'm sorry, I'm going back. One of the paragraphs that they say that was deemed established is paragraph 116, as a direct approximate cause of the breach, blah, blah, blah. He suffered devastating permanent injuries.
I think, Your Honor, that's what I'm saying. I think that they read that as a typo. It's a typo in the brief, and in North Carolina, we don't have law clerks in trial court. The prevailing party drafts the order, but we'll stipulate that's 104 to 106 is what that should be.
So 116 has
116 is specifically not in it. If you look at the C2, paragraphs 112 through 115 and 119, 116 is skipped. So, I mean, to the extent that that somehow creates an abuse of discretion that His Honor did not catch my typo, I apologize. So yeah, proximate causes for the jury, in which deals with this entire argument about why it's so unfair that they should be responsible for the consequences of a defect that they knew about. And And this is what is concerning. Just about the case, this is a appellate argument, so I'm not going to get into the facts like I would in trial court, but Matt was trapped and burned alive in this vehicle over 68 minutes because of a defect that they knew existed in 2013, that they fixed in December 2013, and they hid from us. And that is what the court found. They did IHS testing that they didn't disclose. The IHS, and I'm sorry, I do a lot of product liability cases, and there's a lot of acronyms, so I apologize. It's the Insurance Institute of Highway Safety, and what they do is they do tests that see how a vehicle's perform in real-world crashes. And part of these crash tests that they do is what's called a small offset crash, and that's what this is. It's a frontal collision, but where you hit the quarter panel like this rather than a head-on or rather than a T-bone. And in this test, which we only learned about through the rehabilitation questioning that Subaru and Toyota share counsel in this case, so that their attorney is doing rehabilitation questioning of Subaru's witness, and he brings up, in the FMVSS testing, which is the federal testing that they did disclose, that's not all the testing that you do, is it? And I'm paraphrasing. And he said, no, we also do testing for all these various other, our own internal standards that are higher and stronger than the FMVSS testing, and it's IHS testing, and testing in Europe, testing in Japan, none of which that they produce, and that they do have to provide, or they do have to document. And so we went and looked, and we actually subpoenaed the IHS to get what they had, and they have emails going back and forth relating to this test. And it got a port, and they redesigned this specific part of the vehicle to prevent occupants' legs from being trapped in the vehicle like Matt's legs were trapped in this vehicle for 68 minutes. And that is why the court issued its August 10th order. It was specifically discussed to us, and they're like, oh, well, we have this, we only provide a table. Well, Your Honors, what is a memorandum of law to a trial court but a statement by counsel based on how they see the case? And that's what we provided. It's unsealed document exhibit 1 through 22. And in the hearing, I understand my colleague is appellate counsel. She wasn't there. We went through every single request, including the request in the notice of deposition, topic by topic, and discussed each specific topic. And trial counsel for Toyota was able to make their objections and was able to argue. And so this idea that they didn't have their day in court, that they couldn't, they don't know what they weren't supposed to produce is just false. And I understand my colleague wasn't here defending the case at the time.
So you're talking now about the objections to the topics.
Right.
Okay, so did they object to topics?
They objected to topics.
Was it ever heard by the court prior to the deposition?
It was not heard. That's correct. But
did you have a duty to compel it, or was it their duty to have it heard? I mean,
well, we had.
What did they do wrong as far as objecting to topics? So I guess you showed up for the deposition and they didn't produce anybody to talk about the topics they objected to. Is that correct?
And they also did not produce somebody who's prepared to testify about the documents that they did, or about the topics that they said they're going to produce somebody to testify about. I mean, Toyota's designee said that he was there to testify about the performance of the vehicle in the crash, and said, oh, I didn't look at that. The only thing I looked at were photographs from the consultant that my lawyer hired, that my lawyer's not producing to you because it's a consultant and he's using word product privilege.
So you're saying the witness was not able to testify to the topics that they didn't object to, but what about the topics?
The topics that they didn't. No, they didn't object.
I understand that, but the topics they did object to, did they have a duty to do anything more than just object? Was it a burden on you then to go seek a motion to compel?
Well, considering here's how this situation turned out, and the emails back and forth, and when we send the topics are in the record. I believe it's an attachment to Mr. Clear's affidavit. So I may have the timing right or wrong, but it was about 5-6 months before the deposition, I sent, as I do in all of my cases, Mr. Kiger and Mr. Clear have had lots of cases with me. I sent them 30B6 topics. I sent them requests for production documents with the date and location blank. I said, hey, we need these depositions to move this case along. And they, it took a while to get dates agreed. And so we sent the formal notice, the one that my colleague had mentioned in April or May, when we did, once we got dates cleared. And the first time that we got notice that they're going to object to any of this was 7 or 8 days before the Toyota deposition, which was in Plano.
Is that timely under the rules?
I mean,
37A, does that say 7? I don't know what I don't have that in front of me.
I think it's 30B5 is what they're saying. I mean, our position is that, there's numerous reasons why. This is kind of a straw man argument. Number one, they did have notice for quite some time. It wouldn't make any sense whatsoever for us to try to have to move to compel a court, in this case, to get heard before the I believe it was June 1st was the first hearing, to move within that time, those 8 days, to go get a court in Robeson County to have us heard, to get them to consent to a motion in a shortened time, and then once we got that, and then once it's heard, they're going to argue, oh, well, we don't have enough time to provide a witness who's prepared. And so the situation was, we'd have to cancel the deposition, we'd have to cancel flights, hotel rooms, court reporters, videographers. For the one in Subaru, in any of these cases, you have to have your own check interpreter. So the Japanese, Toyota, Subaru, whoever, Honda, they have their interpreter, and then we have to have our own interpreter because I don't speak Japanese. And so that, and court, certified court reporters, especially in California where all these Japanese depositions take place, are expensive. So we would have to incur tens of thousands of dollars of expenses, just flush them down the drain, when they had 6 months to figure out what they're going to object to, and we could have put it before the court.
But isn't that a unfortunate, potentially economic decision the legislature's made by setting these timing mechanisms? And if you are going to oppose it, the legislature chose to set just 7 days as the limit. I'm sure all these things may have been explored by the legislature and rule creation committees and all that about all these crazy expenses that come with this short window on objections. But isn't that kind of already decided, and we can't really prejudge that equity of the statute, can we?
There's multiple things. First of all, the August 10th order was completely silent, and they didn't say that they waived the objections. And the court never said in the December 1st order that the objections were waived. Just mentioned it as part of it being, this process as being, as their conduct. But again, parties can stipulate to different deadlines. We sent this to them 6 months beforehand, and they never said, oh, well, we can't possibly meet, we need to have all 5.5 months to decide what we're going to object to. And
so there's nothing that in the record that shows an actual stipulation on kind of proposed timing or anything like that.
There's not like a signed stipulation, but the fact of the matter is though there are enough independent bases in this for the sanctions that even if the court were to read in something this court were to read in a waiver of objections into the August 10th, 2023 order where none exists, even if the court were to add a sentence and read in the fact that, it's untimely and thus the objections were waived and not considered in the December 1st order, which does not appear. There's a number of cases that we included in the Memorandum of Additional Authorities. The Bell v. Cunningham, 81 NC 83s from 1879. That says that the judgment's right, it's not going to be reversed because the result is reached in an erroneous process of reason.
Well, this is a little bit different, isn't it? If just one of these legs falls out for you, don't we need to remand it for the trial court to reconsider the exercise of its discretion? These are pretty serious sanctions, and if one of them didn't exist, how can we be sure that the trial court would give such a serious sanction?
Well, first of all, it did not, the trial court considered their objections. And those were considered, and it was not weighed. But I would say that they're right. There are enough independent reasons that they didn't even touch in their brief, even when I mentioned, or their reply, even when I specifically mentioned them in the in our brief, that that there's an independent basis. Basically, the court has to determine that there's no that this was devoid of reason. And even if you say, oh, well, the sanctions were based on, or the timeliness argument was wrong, we still have situations where they, and I can show, they redacted documents regarding other similar incidents after the court told them not to. And I can show that. It's on, it is, examples were in front of the court. It's unsealed document exhibits 315 through 431. They just redacted documents based on something called, quote, privacy. There's no privacy, when the court specifically ordered unredacted documents. I mean, that is just thumbing their nose at the court. And also, other similar incidents are not necessary necessarily, but if they exist, they are relevant to prove notice.
I just want to go down the list.
Yep.
Our first argument was defendants did not comply. The court found did not comply, did not produce everything they were supposed to produce. Give me an example of something they did not produce they should have produced.
Okay.
Because she said that she doesn't know, she's not aware of any document out there.
Must not read the record. So going to...
And I know the witness said that there might have been some testing in the past, but I don't know if there's anything, is there anything in the record that said there's this document that exists or could exist? Subaru's 30B6 designee testified regarding what's called finite element analysis models. These are computer models. And these, you're doing on a computer, those files exist. And those weren't produced. Computer simulated testing and reports, he testified. I'm going off of the unsealed, so it's... What page are you looking at? Do we have that?
I have it's what I submitted to the trial, it's the memo, what I submitted to the trial court. I mean, I could go through and find
that's fine.
depositions.
So you said there are, okay.
And there's what's called LS Dyna models. Again, this is computer models related to that wasn't produced.
Okay, her second argument, they made objections to the documents that were asked to be produced for the 30B6 depositions, and she said the court didn't rule on them because they weren't objected to within 14 days. But
that's just wrong.
That's not okay. So,
yeah, we went through.
The court did rule. The court did consider those objections.
That's correct. If you look at the August, hopefully this is it. All right. I lucked out. 1308 is the order. Is the original order in August 10th. They went over and reviewed and stated in paragraphs 3 and 4 the specific interrogatories and requests for production that they needed to supplement.
And this order was entered after the depositions were taken.
After the depositions.
When the court said, "Okay, I'm going through the objections. You got to produce this stuff." Did they produce it then?
No, I mean they produced. I'll show you what they produced.
So you're saying they still? So even after the court said, "I've considered the objections and I think they're bogus" or whatever, they still haven't produced everything to the court.
That's correct. First of all, they produced these. What I showed, the redacted documents. Documents still contain redactions for matters that aren't recognized under North Carolina law as privilege. Then they produced a bunch of documents that look like this. Now, I don't know whether this is a recipe. I don't know whether this is the results of fantasy baseball draft, or I don't know whether this is a document that relates to specific knowledge regarding the specific defect at issue in this case.
So what did they not produce they were supposed to produce?
They did not produce, and that is listed in what we did submit to the court, which starts on unsealed exhibit 178. They did not produce any testing materials. They didn't produce any computer-aided design or computer-aided engineering files, which is basically like cars are designed on computers. You can't have, they're like, maybe these files never existed. That is impossible.
But you're saying they still exist and they should have produced them.
Yeah, under the document retention policy that they produced to us after the deadline, these documents were still within that time frame, that they would still exist. So the trial court rightfully determined that either they exist, they know that these documents exist and files exist, and the defendants know that they exist, or the defendants didn't look hard enough, or they did exist, and they were destroyed despite the fact this document retention policy says they can't.
Okay, on her fourth argument, making a witness appear in Robeson County, does the judge have the authority to do that?
Under the K2 Asia Ventures case, yes, and that's a case that is a published case under North Carolina Supreme Court that says, or excuse me, Court of Appeals under this court that says that that required a company to put its designee up in California, but even if it didn't, the deposition hasn't happened yet, and because of this situation,
were they sanctioned in part because they didn't produce this witness?
No.
So that's not part of it?
No, it's not part of this.
This is not part, okay. So
that's not part of this appeal at all, or at least, or it shouldn't be, because it's not the basis of the thing. And this court wants to exercise its powers to issue a writ of certiorari and say, well, it should be in L.A. or, the parties should confer.
Now the Japanese, you're relying on that one case from the 70s. Is there that says that they've got to translate it and pay for it?
There is that, but there's also a number of other issues, and so these documents, unlike the documents that are involved in the cases, in the mostly trial court cases where trial courts are exercising their discretion in a different way than Judge Bell did, these documents were not compiled. They were basically like, hey, go to this office and go look at these boxes, and whatever you want, go get them. I think that was the Henri or ex parte Maple case. Here, there is a stipulated protective order, and the protective order puts the onus on the party seeking protection to show the court, to prove to the court that these documents are either confident or are subject to trade secret or proprietary privileges. How could they possibly do that if they can't read Japanese and all they do is read Japanese, or all they do is produce these Japanese documents with no text recognition on it? And they have to have it. There's either one of two things happen. Either Toyota document dumped us with stuff that they don't know what it is, and they did not meet their burden of saying that these documents are subject to contain trade secrets or proprietary privileges, or they know exactly what is in these documents. It's one of two things. They either violated their obligations on the protective order, or they violated the court's order, and they have to produce them, and they have these documents and they have to produce them. But again, and another thing is, one thing that we know about these documents is, if it helped Toyota, they would have produced them to us in English. Because I know who their consultants are. I know if it was something that was going to be helpful for the case that they think was going to prove their defenses, we'd have English translations so the judge could see it and the jury could see it, I could see it, and their experts could see it.
What part, this is where I probably struggle the most, what part of the Rules of Appellate Procedure put an onus on a party to create a document, to create a translation? Because I don't think there's... What did I say? Oh, okay.
I knew where you were going.
I appreciate it.
We're on the same page. It took me a second, but I know where we're going with it.
That's
The-
where
the
I'm really
rules-
struggling, is how this
Yeah.
would apply, universally, if we're saying this is something allowed by the statute.
Well, I think that there's two things. First of all, in this case, it's not just the rules of civil procedure, it's their obligations under the protective order. So that separates it from these cases, because they are affirmatively making a representation to the court that the court must be able to rely upon that these documents are subject to these trade secret and proprietary privileges. So that's one thing. The other thing is that in the Honoré Puerto Rico case, for example, that they say that we're not prepared to say that a court would never be justified in making an order to translate, and that a district court's inherent authority to regulate the terms and conditions of discovery and to make just orders requiring a party to provide or permit discovery may conceivably support a translation order. So, I mean, it's a first district case. There's not a North Carolina case on point, but, other appellate courts have said there are times when the inherent authority to control discovery can allow a party to provide, or a court to issue its discretion and produce these documents.
That last part you add in there gets me a little bit, is the difference between federal courts and our courts on inherent authority when it comes to things that have been supplanted by the rules of civil procedure. I've seen more and more cases from our Supreme Court saying that the pre-existing law has been supplanted in whole by the rules of civil procedure. So is there still inherent authority in our trial courts to act in these further ways that aren't dictated?
Well, I think that when a party does what they did and produces a bunch of documents in a foreign language that they supposedly don't know what's in it and says that it's privileged and they've got that burden, then the court does have that authority. I mean, you can't hide behind these and keep whatever this is from the public and not know what it is. And I think and I'm holding up unsealed document exhibit 236. It was in the unsealed record, but it was marked confidential and subject to protective order. So I think that and also like the parties have an obligation to produce documents that are responsive to specific discovery requests, and if they don't know what it is, if they don't have a summary of these or they don't have a translation of these, then how on earth would they know that whatever 236, 237, any of this stuff is responsive to what request? And how would the court be able to know that? And I think that that's just the fundamental misunderstanding. We're not asking them to create documents. They either have these documents, they have the translations, or they have summaries that say what this is, or they engaged in an improper document dump of 26,000 pages of gibberish that they don't know whether it's responsive or not. And so that is why the translations are necessary. It's not, we have to create documents. It appears that I'm running out of time. The document retention policy, again, the affidavits don't say that the documents were destroyed. It just says that they can't find them. And the court, in its authority as the fact finder, is able to take a look at what the document retention policy is saying. These documents must exist. An affidavit saying we can't find them, and say, in their discretion, either you didn't look hard enough or they still exist and you're lying to me. And so and that's just what the court did. It was wholly appropriate. Again, they're just kind of nibbling around the edges of this order. They cannot possibly meet their burden of proving an abuse of discretion under these circumstances, especially when there's conduct that they admit, that there's conduct that violates the court order that they don't even try to explain away in their brief. So, Your Honors, we would ask that the order be affirmed, and we would ask that the case be remanded for trial on the issues of proximate causation and damages. And thank Your Honors for your time. If they do get into any of the specific requests themselves or specific privileges, I would like the chance to respond because they haven't yet in the year of appellate argument.
Thank you.
So,
Thank you.
Thank you.
Rebuttal?
Thank you, Your Honors. There were some questions about what was admitted and what was deemed admitted. Appendix 10 has the following facts that are designated as established and touched on those that they jointly designed and developed in the vehicle, and they had constructive knowledge that they were defectively designed. The order, the sanctions order, ordered that at record 1896, that paragraphs 104 through 116 be admitted, and we identified that issue in our brief, and those paragraphs include a statement that as a direct and proximate result of the negligent and grossly negligent conduct of defendants, Mr. Sessoms suffered severe, permanent, and
Well,
catastrophic.
he's conceded that was a mistake, and so he's okay if we enter an order, in our opinion, to just basically strike that. He's conceded that,
Well,
that particular one.
so that concession could have been made sooner and would have been helpful, but it goes to show that the trial court just blanket adopted the orders without thoughtful care, resulting in severe sanctions. So even without the proximate cause, the defendants are severely limited in what they can do on remand. We have the affidavits detailing what was produced, including affidavits showing a supplemental production. The EDH site, Justice Berenger, is 381 NC 395. The plaintiff, there was a lot of discussion about the timing around the 30B6, and of course the plaintiff could file a motion to compel after the depositions occurred, but instead essentially jumped to the sanctions.
Well, he said the judge in its discovery order after the depositions did review your objections and ruled against you and told you to produce the documents, and that y'all did not produce them.
And
I guess would have resulted in the sanction order. How do you?
Respectfully, we disagree that we didn't produce the documents we were ordered to produce, one, and two, those references that he made were to the request for production of documents and interrogatories, not the requests that came with the 30B6 notice. The defendants didn't object to reconvening the depositions. We objected to reconvening them in Robeson County. And the defendants were ordered to pay and did in fact pay the plaintiff's expenses for those initial depositions.
Counselor, I'm still trying to figure out, how are you producing documents that you can't even read?
Thank you, Your Honor. So these are Japanese companies, and
That chose to do business in America.
absolutely, and it's a very highly regulated industry, and the federal government requires all sorts of testing and documents, and all of those documents have been produced in English. The documents that are required to be maintained by the federal government in order to sell a vehicle in the United States. The defendants are foreign companies. They have people in those Japan who assist them in pulling the documents. Those people know what the documents say, and this is an issue of cost, and it doesn't rise to this issue, this just devastating sanctions. And as Judge Murphy pointed out in his questions, if any element of this sanctions order fails, then it all fails, because how otherwise you have to substitute your judgment for the trial court's judgment, and you would have to say, oh, I think the trial court would have issued these case dispositive sanctions based on these 3 violations, even though we agree that the other 3
But
didn't.
if you don't translate the Japanese documents, what about his argument that the gibberish document that he holds up, you should have at least labeled or said what it is. What is this in response to? Or did you do that?
I'm sorry, Your Honor, I don't know the particular circumstances of that
Okay.
exact document.
Okay, that's fair. And you need,
I've got jurisdiction questions, 'cause I know you're kind of out of time already.
Yes.
If it's stipulated to that 106 through 116 in the complaint should not have been deemed admitted as or established by a sanctions order, and causation is not established yet, isn't this back to being an interlocutory appeal because the sanction isn't basically striking your answer and giving judgment to the plaintiff? There's still the causation issue?
Well, Your Honor, it strikes.
It strikes a lot of portions of it.
It strikes a lot of it, and we would be left without a defense on the unfair and deceptive, except for causation. I mean, they're 90% of the way there, and the Moore case that we cited, says when it's this bad, you need to look at it. Most of the cases where this court has upheld sanctions that are this severe are situations where the parties just didn't participate, just didn't show up, just didn't serve interrogatories, just had their depositions noticed and didn't come. That's not this situation. These parties proceeded with discovery for a long time until plaintiffs decided to weaponize discovery and focus on obtaining sanctions in order to get their case won instead of focusing on the merits. Plaintiffs still did not point to documents that exist that were not produced. When Your Honors asked him to identify documents, he talked about documents that he believes existed. No evidence they actually
I'll give you 1
exist.
minute to wrap up.
Thank you, Your Honor. This case is important to the citizens of North Carolina. Our courts exist to adjudicate such disputes. The awful circumstances of this case are no reason to set aside the rule of law and fundamental fairness and make the manufacturers of the vehicle the decedent was driving almost strictly liable. Rather, this case should be decided on the merits, not on the outcome of discovery disputes fomented by plaintiff, decided on errors of law, and that Toyota defendants attempted to resolve in good faith. The Toyota defendants respectfully request that this court find it has jurisdiction over the entire appeal and reverse both orders so that this case can be tried on its merits. Thank you.
Thank you. We'll take it under advisement. Thank you for your arguments.
Thank you. Thank you. Good job.
Safe travels. Good luck in wherever the heck you're going today.